Hello, everyone, and welcome to our third installment of our employee conference webinars. We're so excited that you're here today. We're very excited for our presenter, and I'll get to our presenter here shortly. But we first wanted to just formally welcome everyone and tell you that we appreciate your time and your interest in these topics. During this unprecedented time, we know that we've had to kind of modify things. We've always done our client conference in person, and we're sad that we're not able to see everyone's smiling faces, but we still wanted to provide you with as much education that we could and let you know that we're thinking of you and we understand some of the unique challenges and obstacles that you face as employers, especially with everything going on here in 2020. So that being said, we wanted to just remind you that you're all in listen-only mode, but we do encourage that you ask any questions, or if you have any comments, please type them into the slots that are available so that we can get to those. We're planning on taking a few minutes after the presentation to answer any questions, or even during the presentation, if there's a question that comes up that we feel is relevant, then we'll interject and answer those questions. So feel free to type in those questions as they come up as our presenter goes through her slides. The webinar is also recorded, so if you have to leave early, or if you've registered and you're not able to attend in person, we will be sending out this recording after the webinar is completed, sometime the middle of next week. The other thing that we wanted just to quickly touch on is the Beehive services. So this slide gives you just a brief overview of what we offer to all of our clients. It's not a complete list, but we wanted to kind of give you an idea of what's out there and available to you. Most of you are probably utilizing a lot of these services already. HR 360 is a great resource, a great tool for HR related issues and questions. Hive Plus also gives you access to some free legal consultations. VicTig is our background screening partner. So as you look through this list, if there are questions that come up, or if you want to get additional information about any of these items, please reach out to one of us here at Beehive, and we'd be happy to talk more about each one of them and provide you with additional information. So that being said, we want to move forward and would love to present our speaker today. Our speaker is Katie Templin, and she is with NBS, National Benefit Services or Solutions. Katie has been with NBS as the Director of Business Development for almost 5 years. She has her health and life insurance license and has been working in all aspects of employee benefits for over 8 years. She specializes in consulting with brokers and employers to find solutions to help employees get the most of their benefits, as well as ensure plans remain in compliance and up to date with IRS regulations. She has 2 dogs, loves to play golf, and I can attest to this. I've played golf with Katie, and she is a very good golfer. She loves to watch sports and spend time with her family. We're very excited to have Katie with us. She's going to provide us with a lot of great information about compliance and some good things that you may know already but need a refresher on, or may not know. And so we'll turn the time over to Katie, and then after she's done with her presentation, we'll open it up to questions.
Okay, thank you very much, Mike. I think you're being generous when you say I'm a great golfer, but I appreciate that. We're really excited to be here with you all today. Like he says, I am the Director of Business Development with National Benefit Services. We are located here in West Jordan, Utah, and we've been around for over 34 years now. So We've partnered with brokers across the state and across the country for years now, just as Mike mentioned, doing consultations, trying to figure out which benefits are going to be best for your employees. I've also worked on the insurance side, so as a broker. So again, I've seen these benefits inside and out from all directions and different questions and things that have come up. So I'm excited to be here today to share a little bit of that knowledge with you guys. Just kind of to give you an idea of what we're going to be going over today, COBRA basics. So what's required of you as an employer when it comes to COBRA, some of the notices that are required, and details surrounding that. Mini COBRA here in Utah is also required, so we'll touch on that a little bit. And then I'm going to spend the remainder of the time kind of going over some of the changes that have come about due to COVID-19, the coronavirus, and the IRS, the Department of Labor and Health and Human Services have come out with several different notices to kind of help guide you and your employees through this time. So we're going to be going over some of that as well. So probably not the most exciting topic, but still appreciate you all being here today because this stuff is important. Your teams at Beehive are great, and so I know that they do everything they can to help you with this. But please don't hesitate to ask questions as we go along, or I can answer them at the end as well. So as I mentioned, we're located in West Jordan, Utah. We actually have 4 different offices. So our headquarters are here. We have an office in Dallas. We have an office in San Diego, as well as in Honolulu. So we do work with clients in all 50 states, but we have a large presence here in Utah and in those locations, hence why we have offices there. So our founder and CEO, Paul Lovell, he's the one that started NBS, and the reason he did that is he's an ERISA attorney. So he actually started writing plan documents for 401k plans and cafeteria plans or Section 125 plans. And then it's just kind of evolved from there. So given that our roots are from an attorney, we're very compliance driven in everything that we do. And we want to ensure that we're doing the right things by our clients, and that if you were ever to get audited for any reason on any of the lines of coverage that we offer, that we're there to support you in that. So a little bit more background. We are kind of split into 2 divisions when it comes to NBS. I work in the benefits side. So that's going to be all of your FSAs, HRAs, HSAs, COBRA administration, things that you guys are probably pretty familiar with, but we also do retirement administration. So 401k and 403b admin. I don't work as much in that space, and we're not going to touch on that today, but that just kind of gives you an idea of who we are here at NBS. So jumping into the really exciting stuff, COBRA. So we're all glad that it's called COBRA and we don't have to say this long name, but the Consolidated Omnibus Budget Reconciliation Act, it was actually passed back in 1986 is when this was put into place. And so basically, just high level what COBRA is, it protects employees and their dependents when they lose coverage under a group health plan. So if they're an employee with a company, they're offered benefits, they lose that employment, then COBRA is there to protect them to allow that continuation of coverage if they need it. So it is a federal law, and it applies to all businesses with 20 or more full-time employees. And so what that means is it's 20 or more employees on at least half of your regular business days in the last calendar year. So if you're kind of teetering on that border, you can work with your Beehive team to calculate that. But again, it's 20 or more employees on at least half of your regular business days. And then these regulations would apply to you. So how does COBRA work? As I mentioned, when an employee loses coverage, this allows them to continue that coverage on their group health plan. So there are some exceptions. They cannot be let go for gross misconduct, and we'll talk about a few of those qualifying events later on. But basically, majority of the time, as long as it's not gross misconduct, an employee loses coverage to that employer, COBRA is going to give them the right to extend that coverage. They're going to pay the premium. Most employers are generous enough to at least a portion of the employee's insurance premiums. So when they get the notice that tells them how much these COBRA premiums cost, people are usually pretty shocked. Because they're going to be paying 100% of the premium as well as a 2% administration fee. So whatever the cost is for that employee, they're going to be paying 102% of it. So depending on what the employer was paying when they were an active employee, again, it can be a pretty eye-opening number when they receive that notice. So they lose coverage. They have the option of extending it and paying that premium. The length of coverage is going to vary between 18 and 36 months, depending on what the qualifying event is. And again, we'll go into a little bit more detail on that. But the regulations are complex, and there can be a lot of penalties if you're not staying compliant with these types of things, which is why it's great that you have a team like Beehive and they partner with us at MBS just to make sure this runs smoothly and doesn't add a lot of administrative work on your guys' end, because we know you're already wearing lots of hats usually. So who is eligible for COBRA? This would be called a qualified beneficiary. So a qualified beneficiary is generally whoever is covered under the plan when they're an active employee. So that could be just the employee, it could be an employee, their spouse, and any of that employee's dependent children. So as I mentioned, what is a qualifying event? So what allows an employee the option to enroll in COBRA? Some of the more common ones we see for employees are obviously going to be voluntary or involuntary termination. And again, that's for any reasons other than gross misconduct. So when you terminate somebody for gross misconduct, you want to ensure that that's really gross misconduct, because otherwise they won't be eligible for this COBRA coverage. Reduction of hours of employment is also a qualifying event for the employee. If you are a spouse, obviously the qualifying event could be same, reduction in hours or voluntary or involuntary termination to that employee that you were enrolled under. It could also be the covered employee becomes entitled to Medicare. That's going to give the spouse the option to enroll in COBRA. Divorce or legal separation also allows that spouse to enroll in coverage, and even death of the covered employee. If you're a dependent child that's on that employee's plan, aging off of the plan is a COBRA qualifying event. So once that dependent reaches that age, they have the option of enrolling in COBRA. So those are a few of the more common reasons that we see as qualifying events. So required notices. So there are a lot of notices that are required as part of this COBRA law. The first one is the initial or general notice, as it's often called. This is the notice that goes out to employees just to give them their general COBRA rights. So this notice must be provided within the first 90 days of coverage under the group health plan. So all new employees need to make sure that they're getting this initial notice. Again, a lot of times it confuses people because they'll get this notice and be like, wait, why am I getting this? But it's really just telling them what their rights are under the COBRA laws. So it's important that that goes out to them. The COBRA qualifying event election form. This is, as it sounds, an election form. So this is when a qualifying event has occurred. The employee has the right to elect the COBRA coverage. So this notice is required to go out. It needs to have some required information on here. So it needs to basically say the name of the plan and who's going to be the COBRA administrator. It needs to identify what that qualifying event is to the employee. It needs to tell the employee how they can elect the continuation of coverage, how much their premiums are going to be, where they need to send those premiums. So basically the nitty-gritty of what the COBRA coverage entails. And this is usually, again, when employees are shocked about that 102% fee that is associated with COBRA. But again, this gives them all of that information so they can determine if COBRA is the right option for them. Unavailability of coverage. So if for any reason they're denied coverage, they need to be provided notice of why they're denied that coverage. underpayment. So as an employee, you've now enrolled in COBRA, you're paying those premiums. There is some time to bring the premium payments whole, and there's a little bit of grace period each month within paying those actual premiums. But if for any reason you underpay, the administrator is required to tell you that you've underpaid your COBRA premiums and allow you time to bring that whole before they terminate your coverage. Termination of coverage notice. So again, once they've stopped paying the premiums, you need to notify them what their last day of coverage is going to be. If there's any change in COBRA premiums, again, this often happens around open enrollment, so these last two generally go together, but anytime there's a change in COBRA premium, you need to notify the COBRA participant of that so they can ensure that they're sending in the correct amount. Open enrollment information, this is a big one because open enrollment is a crazy time, right? Everyone knows that. There's a lot of things going on and a lot of moving pieces. And so you need to make sure that you're giving any employees that are enrolled on COBRA the same enrollment rates that you would give any of your active employees. So making sure that information is getting distributed to them as well. So those are just a few of the notices that are required as far as COBRA. So within those notices, there are some deadlines and requirements that must be met as well. So an employer has 30 days from the date of termination or the date of that qualifying event to notify either NBS or whomever your COBRA administrator is. So an employee terminates, you have up to 30 days to notify them. That administrator then has 14 days to actually send the qualified beneficiary information to that employee. Once that has been set, the employee has 60 days to enroll in COBRA. So they have some time to determine once they receive that information if this is the best option for them, or if maybe they're changing a job and they can get insurance sooner through that employer, or whatever their situation may be. They have 60 days to actually enroll in the COBRA coverage if they wish to do so. And then from there, they have 45 days to bring all of the premiums current. So they'll need to bring the premiums current back to the date of the qualifying event. So just make sure that they're getting all of that payment to whomever the administrator is. So again, it's really important that these timelines are being met. So when you terminate an employee, you need to make sure that whomever is handling this COBRA for you, whether you're doing it internally or outsourcing it, that you're notifying them so then they can start these additional steps to ensure that you're remaining within this timeline. And again, that just goes to keep everyone in compliance. So once they've elected coverage, COBRA requires that the continuation, it depends on what the qualifying event is. So we'll talk about some of the differences here, but the coverage is basically for between 18 and 36 months. So let's look at that a little bit more closely here. So if it's termination or reduction in the hours of employment, which is probably our most common qualifying event, the qualified beneficiaries are going to be anybody that was enrolled in that plan, and they can have that coverage for up to 18 months. If an employee enrolls in Medicare, they are eligible or entitled to Medicare coverage. The qualified beneficiaries there are going to be the spouse or dependent, and they can have coverage for up to 36 months. This gets a little bit tricky, and we'll talk about this a little bit more in some slides that are coming up. But that is a qualifying event. Divorce or legal separation, again, qualified beneficiaries would be the spouse or dependent children. They have the option to continue that coverage for up to 36 months. Death of the employee, also 36 months. And then loss of that dependent child status. So again, this is when that dependent child is aging off of the plan. This allows them that continuation of coverage as well. So, okay, as promised, the very exciting Medicare rules. And these get tricky. And so again, if you have these situations occur, you can consult Beehive, you can consult us at NBS. but it's important that you know these rules. So if you can you have COBRA and Medicare together? We get asked this question all of the time, and it really depends on when you become eligible for each. So if your Medicare benefits become effective on or before the day you elect COBRA, then the COBRA coverage can continue. But if you become entitled to Medicare after you sign up for COBRA, then your COBRA benefits end. Okay? So if you become entitled to Medicare after you've signed up for COBRA, your COBRA benefits completely cease. Again, your dependents and your spouse can still have coverage if you're on Medicare, but it's important to know that it depends on when you're entitled for the Medicare and when that qualifying event actually occurs. So hopefully you can see this okay. I know it's a little confusing, but essentially, so the first date here is May 15th, 2017. So this is the date that the employee becomes entitled to Medicare. They continue working for an additional 12 months. So the next year, May 15th, 2018, this is triggering a qualifying event. So they're either terminated or have a reduction in hours. That qualifying event gives that employee the option to enroll in COBRA for up to 18 months. But the date that the employee became entitled to Medicare triggers the coverage for the spouse and dependent for up to 36 months. So we say up to 36 months because you can see there's a 12-month time frame in which the employee was still an active employee, and then there's 24 months after the qualifying event. So if a covered employee becomes entitled to Medicare 12 months before his or her employment ends, COBRA coverage for his or her spouse and children would last 24 months. So again, you take the entire time, 36 months, you subtract 12, and that would allow this spouse and dependent children to continue their COBRA coverage for 20 months. So for another example, say that the date the employee becomes entitled to Medicare is May 15th. 6 months later is when they trigger the qualifying event. So rather than having 12 months, they only have 6 months of active employment. You take the 36 months minus the 6 months, the employee was still a covered employee, and that spouse and dependent would then be eligible for Medicare or for COBRA coverage for 30 months instead of the 24. So whatever the time difference is between the date that the employee becomes entitled to Medicare and when that qualifying event actually occurs, you subtract that amount of time from the whole 36 months. So I know that can be kind of confusing, but again, the date they come entitled to Medicare, the date the qualifying event actually happens was a 12-month span. So you take 36 months in total, subtract 12 months before the qualifying event happened, and that spouse and dependents have COBRA coverage for an additional 24 months. So that's how you determine that. And again, as you can tell, it gets a little tricky. So if there's ever questions or things that come up, be sure to consult Beehive or us, like I said, us at MBS. We're happy to walk you through that. But hopefully that kind of gives you a rough idea of how it happens. Okay, early termination. So employees in elected COBRA, say they have up to the 18 months or 36 months in the Medicare scenario. Are there any reasons that would cease? Yes. So if they're not paying their premiums in full on a timely basis, that's going to terminate their coverage. Again, a qualified beneficiary becomes entitled to Medicare benefits, or there's a voluntary request to terminate. If they keep paying those premiums, they're going to keep having that coverage for as long as the regulations allow, depending on what their qualifying event was. So again, if it's terminated early, one of the notices that we mentioned is the early termination notice. And so as the employer or as the administrator, we're required to let that employee know they've been terminated from coverage and what their actual last day of coverage is going to be under their COBRA coverage. All right, so if you've sat here and listened to me totally confuse you about Medicare coverage and all of the notices that are required, and you're saying, I don't even have 20 employees, there's still some rules that you need to be aware of. So in Utah, employers are responsible for providing Utah Mini COBRA. And if you have under the 20 employee mark, which requires the federal COBRA to kick in. So there are a few differences from Mini COBRA to federal COBRA. So one thing is that there's no initial notice requirement under Mini COBRA. So when an employee gets hired under federal COBRA, as I mentioned, you're required to provide that initial notice within the first 90 days of being on that group health plan. With Mini COBRA, you're not required to provide that. So there's just the election notice. So only when there is a qualifying event do you need to provide any sort of notice to employees. The other caveat is employees must have been on the plan for at least 3 months. So if the employee has not been there long enough to have group coverage for 3 months, you are not required to offer them Mini COBRA. So that is another kind of caveat that is to be aware of. They have 60 days to elect from the loss of coverage, so that's the same as federal COBRA, but the law does not make any note of time frame on how employees have to bring their premiums current. So again, in federal COBRA, they have 45 days to bring those premiums totally current. Mini COBRA laws don't state what the time frame is on that. So again, there are a few differences that occur between Mini COBRA and federal COBRA, but it is still important that you're providing them with those election notices if it's applicable. And then again, the time frame in which the coverage continues is only 12 months under Mini COBRA instead of 18 or up to 36 when it comes to federal COBRA. So common mistakes, again, when it comes to federal COBRA, providing that general or initial notice. Again, there's a lot of steps in the onboarding of a new employee, and so making sure that you're getting them all of that information, including their general rights notice, is important. Failing to give election notices for qualified beneficiaries, I would say more in a timely manner, because again, you have 30 days to provide your administrator notice of that termination, and then that administrator, whether that be you or NBS, has 14 days to send that. So again, you're going to want to make sure that that's done within that time frame. Again, failing to offer open enrollment, as I mentioned earlier, there's a lot going on at that time. And so again, just making sure that you're giving those COBRA participants the same enrollment rights that your active employees have. Misunderstanding the Medicare requirements. You still may not understand the things that I said about that, and that's okay. That's what we're here for. So if those kind of questions come up, please let us know. And then just failing to document when notices were sent. So that's a big part of it. If an employee ever came back and says they didn't get a notice, you're going to want to have that documentation that proves those were sent and within a timely manner. If you don't send notices, qualified beneficiaries can sue to recover COBRA coverage. And we've seen this happen. So employers will come to us and say, we got sued, now we need someone to cover this, this is how much we had to pay. So this kind of stuff does happen. Tax penalties can be assessed by the IRS up to $200 per day for each day in which a plan fails to comply with COBRA. So that can add up pretty quickly. And then penalties of $110 per day may be recovered for the plan administrator's failure to provide certain notices. In lawsuits under ERISA for COBRA coverage, the court is permitted to award attorney fees to the prevailing party. So again, attorney fees and interest on those fees can add up pretty quick. So you want to make sure you're following those timelines and sending out the notices accordingly, so you remain in compliance. Again, with all of the changes that have been happening under COVID-19, there have been some changes in relation to COBRA coverage. So the IRS, the Department of Labor, and Health and Human Services issued some guidance on May 4th. Normally, as I mentioned, an employee has 60 days to elect their COBRA. That's what the regulations state. But this guidance that was provided says that under this rule, the 60-day time frame doesn't start until the end of the outbreak period. So again, this allows employees additional time to be able to make those elections. The COBRA premium payments, again, normally have to be brought whole within 45 days. The new rule extends the initial premium payment and grace period deadlines beyond the outbreak period. So really, this is just kind of an open door for employees to be able to still elect or pay their premiums if they've lost their job or their coverage during this pandemic. It's expected that these will end, obviously, so this isn't forever changing guidance, but for the interim, there's a lot more flexibility in those deadlines. All right, so we're going to switch gears here a little bit. So if you have specific COBRA questions, we can answer those now, or we can wait till the end. But I'm going to kind of switch gears and talk some more about the changes associated with COVID-19 and the regulations around that. So as I mentioned, we do COBRA coverage, but we also do a lot of Section 125 or cafeteria plans, which can mean a lot of different things. So specifically flexible spending accounts, health savings accounts, health reimbursement arrangements, those types of plans. There's been some significant changes to the regulations of those. So qualifying events, we're all familiar with what those are. Usually it's going to be marriage, birth of a child, death, divorce. Once you make your election during open enrollment, you are not allowed to change any of those things until the following enrollment period unless you have one of those qualifying events. The CARES Act made it so you can have mid-year election changes with some certain specifications. So you can make a new election to participate in an employer-sponsored health coverage if you initially declined. So open enrollment was there, you didn't need coverage, something happened during this pandemic, you now want to, you may be able to. You can revoke elections. Specific to health FSAs, you can revoke, make a new election, or increase an election to your health FSA account. So this is new. Again, generally speaking, once you make that election, there's no changes to that unless you have a qualifying event. This is something that you will need to amend within your plan document. So you can't just do this. You do need to make sure that the language is included within your plan document to allow for these mid-year election changes. The special accommodations may be applied retroactively to mid-year changes. So you can retro back these changes to January 1st, but they will expire on December 31st, 2020, unless at that time they decide to extend it. So again, this has been a very fluid year, right? There's been so much change and so many things that have happened. And so we're going to say right now that it's expiring on December 31st, but if this continues, they may come out and change the regulations again. So do be aware of that. You will need, as I mentioned, to make an amendment to your plan document. The IRS hasn't actually released the language that's required in the plan document. So you can say that you want to amend the document, and we'll do so as long as they provide us that language. But the key is it just needs to be executed by December 31st of 2021. So you can say, hey, as of today, NBS, we want to amend our plan document to allow for mid-year election changes. We'll make note of that. We'll allow you to make those changes. Once the IRS provides us with the language to put in the document, we'll do so, and then that needs to be signed by the end of next plan or the end of next calendar year to ensure that you're in compliance. So they're giving themselves a lot of time to release that language and get everything signed, but you can go ahead and start allowing for these mid-year election changes now if you want to do so. We expect, and again, we don't know for certain since they haven't released the language, but we expect that they're going to say that during this time frame, mid-year election changes are allowed, rather than putting in language which would then have to make you go back and amend your plan documents again. We hope that's what they do, but again, we're not entirely certain. So again, these mid-year election changes are currently being allowed if you want them to be allowed. You just need to decide if that's what's best for your population. And if we're your administrator, or again, whomever your administrator is, let them know, and so they can make note of that, and they'll get you those updated documents as soon as the IRS releases that required language. Okay, one of the other changes that they have allowed is grace period extension. So you have an FSA plan. As you guys all know, it's usually a use it or lose it type of plan. So employers with either a grace period or a plan year ending in 2020 may amend their plans to allow employees to use unused funds through December 31st of 2020. So say your plan year ends June 30th, you have a 1 month grace period. So that would go through the end of July. Usually that's when whatever hasn't been spent in that account is forfeited by the employee. You can add, again, this is a required amendment. You can add this amendment into your plan document that allows employees to have throughout the rest of the calendar year to spend those funds. Again, we've all been cooped up. We all haven't done some of the things that we normally do if you were supposed to have an elective surgery, and that's why you put your FSA funds away and it got shut down due to all of this, and now you have all of this extra money. This is just giving you a little bit more time to be able to spend those funds. So that's how that'll work. It's also effective. The temporary extension for incurring claims is available to FSA plans that offer both the grace period and the carryover. So again, there's some flexibility in that. If you want to give your participants or your employees some additional time to spend those funds, let us know, or let your plan administrator know, and we can help you make that amendment. Again, these plan documents and these amendments just need to be executed by December 31st of 2021. That sounds like it's a long ways away, but you know, it'll probably be here before we know it. Okay, another change is the carryover increase, and this is actually a good thing. So if you've participated in FSA plans in the past, you probably are aware that each year they index the total annual election amount by $50. They're going to now start doing that with the carryover as well. So the carryover amount for FSAs has increased from $500 to $550 to account for inflation. This is something that you can opt into if you want to allow for that increase, if they continue to increase it. It is a permanent increase. So all of the other changes that I've mentioned so far expire on December 31st of 2020. This is something that'll continue each year. So again, an amendment is required. And the other difference with this carryover increase is that you must execute the plan document and the change by the end of the plan year in which you're making the change. So if your plan year again ends June 30th, you want to opt into this carryover increase, you need to have that executed by the end of June 2021. You don't have until December 31st as you would with the other two changes. So a few little differences. Again, that's a permanent increase rather than a temporary change, and the document needs to be executed by the end of the plan year in which you're making the change rather than December 31st, 2021. The run-out period. So you may have a run-out period regardless of if you have a grace period or the carryover feature, but the IRS has suspended any run-out periods. So if you have a run-out period, you have until the end of the national emergency, which they have not announced. So you're no longer able to spend funds when you're in your run-out period. It's simply just the time for you to submit receipts for claims that were incurred during your plan year. So again, the plan years are extended, the run out periods are extended. It's basically just giving employees every opportunity they can to spend the funds that are in these accounts, which is a good thing because I think all of our lives have been kind of thrown for a loop. We're out of our normal routines. You may have forgotten to submit a receipt or do something that you normally wouldn't have ever thought twice about. So again, grace periods can be extended, carryover increase, and then the run out period. Those are some of the key changes in regards to your flexible spending account plan. Another change, and this is actually an exciting change. This is something that probably my most asked question when we talk about either FSAs, HSAs, HRAs is, can I pay for my over-the-counter medications? And the answer for a long time has been no. The IRS has limited that as an eligible expense. And so they've finally opened that up a little bit. Over-the-counter drugs and medicines are now eligible for reimbursement. So you can now buy your over-the-counter allergy medicines, Tylenol, things like that that you couldn't buy before without a prescription are now eligible under 213. So 213 is the IRS code that states what's eligible under these plans. They're expanding this. This is an automatic change that happened as part of the CARES Act. So everything else that we've talked about was an optional change. You can opt into those changes and amend your plan document, or you can say we want to keep it as is. With the over-the-counter drugs, this is an automatic change that's happened across the board. So your amendment will automatically happen. And as far as we're aware, this is going to be a permanent change. So this is going to be something that for years forward, you'll still be able to use your FSA or HSA dollars to buy your over-the-counter medication. So this is a big deal, and we're really excited about it because I think this is, like I said, probably the biggest question that we get. So it'll be nice to be able to use your funds for these expenses because we all have them. The other thing that changed as part of that is menstrual care products. So those were never a qualified expense under an FSA plan. They now are. So any of your over-the-counter menstrual prescriptions, Tylenol, anything pictured or under that category is now a qualified expense, which is also helpful because, again, say you put all of this money aside expecting that something you were going to have a procedure or something was going to happen and it didn't happen. Now, if you have extra funds that you're at risk of losing, you can stock up on some of these things that it's just nice to have around your house and limit the amount of forfeiture that you have. So this really gives employees or participants in these plans just a few more options. Okay, and then one other change that occurred, and you guys may be aware of this, as I know that Beehive helps with a lot of telehealth services, is if you're on a high deductible health plan, you usually don't have any first dollar coverage, which means the insurance isn't going to pay anything until you meet that deductible. They're making exceptions to that rule under the CARES Act if you're doing anything with COVID-19 testing or treatment. So again, this provision is effective immediately and will expire at the end of the plan year. So another nice feature, just in case you are affected by this in that way, you have coverage and you don't need to worry about a lot of out-of-pocket expenses to you to be able to be tested or treated during this crazy time. So I know that was a lot of information and a lot of riveting stuff, but do you guys have any additional questions around compliance, whether that be with COBRA, whether that be with some of the CARES Act changes or anything else?
Hi, Katie. It looks like we don't have any unanswered questions right now. If there is anybody with questions, please enter them into the chat bar or the questions section so that we can get to you with those answers. We would love to help you out and make sure that you fully understand what needs to happen with COBRA and compliance. You can also contact your account manager if you have questions that come up later or anything else that you need to have answered.
Okay, well, we want to thank Katie for her time and for all of the really great information. You don't realize how much detail there is in these compliance topics until you really dive into it, and a lot has changed in a very short amount of time with COVID. And the good news is we don't expect you, and I say this a lot to my clients, we don't expect you to be insurance experts or compliance experts. So that's what we're here for, is to provide you with as much education as we can, but also to tell you that we're here to help with anything that comes up. We work with NBS uh, primarily because they're the experts. And so if any COBRA question comes up, please let us know, or let Katie know, and we can help. The other nice thing with NBS is, instead of having to administer all of the COBRA in-house, or trying to figure it out on your own, Beehive pays for any and all of your COBRA administration, and then NBS will take over and take care of all of the notices and all of the information that needs to go out to those employees. So thank you so much, for Katie, for all of your really useful information and for your time today. Again, like Laurie said, if you have any questions after this webinar, please feel free to send an email to someone at Beehive or to Katie, and we'd be happy to answer those. We're going to end now and give you a little more time to enjoy your day. Please remember that we have 2 remaining webinars coming up. The next one is next Wednesday at the same time, and we look forward to seeing you then. Please feel free to reach out to anyone here at the team with Beehive if you have any questions, and we hope you have a great rest of your day and a good weekend. So we'll end on that note and look forward to seeing you next week.